Hello everyone, and welcome to the November 2025 edition of My PIP Monthly. This month's presentation is brought to you by Senior Partner Mark Masters and myself, Executive Partner Caitlin Milroy. Today's topics first include our usual most recent case law update. The first case we will discuss is the recent to be published opinion of the Court of Appeals that was issued on October 29, 2025 of Encompass Healthcare PLLC versus Citizens Insurance Company. The second case law update is on the unpublished opinion per curiam of the Court of Appeals that was issued on October 23, 2025 of Dionna Stubbs-Barrett versus USA Underwriters and John Doe. Lastly, we will focus our discussion on a trending topic of PIP litigation pertaining to the parked vehicle exception under MCL 500.3105 subsection 1 and its potential tie to property protection insurance benefits or PPI benefits. For this, I will give a brief overview on the topic and statute. There is also a recent to be published decision of the Court of Appeals of Fremont Insurance Company and Frankenmuth Insurance Company versus State Farm Mutual Auto Insurance Company and Jeffrey Lynn Gibbs that was issued on November 6, 2025 that will be discussed. The first case we will discuss is the recent to be published opinion of the Court of Appeals that was issued on October 29, 2025 of Encompass Healthcare PLLC versus Citizens Insurance Company. This case discusses the amended one-year back rule under MCL 500.3145 and whether same should be retroactively applied. This seems to be a constant existing argument in the no-fault world that was further heightened by the spine specialist decision from the Supreme Court in 2022. As we know, in June 2019, MCL 500.3145 was amended to add a tolling provision for accrued claims for medical treatment that had not been formally denied by an insurer. In this particular case, Ronald Maynor was injured in a December 2017 motor vehicle accident. He later developed a pressure sore, treated with plaintiff Encompass Healthcare from June 2018 to October 2018. This treatment was notably provided before the amendment was in place. Over $900,000 was billed by Encompass, and Citizens paid over $170,000 of that bill. In this case, the trial court and the parties had proceeded implicitly or explicitly with the understanding that the amended version of MCL 500.3145 applied retroactively to this case. So the outcome turned on whether the explanations of review forms defendant Citizens provided to plaintiff Encompass and the insured constituted a formal denial under MCL 500.3145 subsection 3. As we know, in 2022, the Michigan Supreme Court ruled in the case of Spine Specialists of Michigan PC versus Member Select Insurance Company that the amended statute should not be applied retroactively. The Court of Appeals in this case later vacated the trial court's opinion in this case and remanded the matter for reconsideration in light of its holding in Spine Specialists. On remand, Encompass asserted that the Supreme Court did not decide whether Citizens waived its challenge to retroactive application of MCL 500.3145 subsection 3 by neither presenting the issue to the trial court nor initially raising the issue in this court. Thus, Encompass urged the court to rule that the issue is waived. The court rejected this argument. The court found that Encompass's claim based on medical treatment accrued when that treatment was provided between June 2018 through October 2018. As a reminder, the amended version of MCL 500.3145 went into effect in June 2019, as we know. And Encompass filed its complaint against Citizens in this case on November 4th, 2019. Pursuant to Spine Specialists, the pre-amendment version of MCL 500.3145 and its strict one-year back rule bars Encompass's recovery for medical treatment, which accrued before the complaint was filed on November 4th, 2019. Because the pre-amendment version of MCL 500.3145 applies in this matter, the court found it was immaterial whether the explanations of review constituted formal denials, because the amended version of MCL 500.3145 subsection 3 with its added tolling provision did not apply. Thus, the trial court's reliance on the amended MCL 500.3145 subsection 3 must be characterized as erroneous. So citizens must be awarded summary disposition of all claims based upon medical treatment that accrued before the complaint was filed. The second case law update I have for you is on the unpublished opinion per curiam of the Court of Appeals that was issued on October 23, 2025 of Dionna Stubbs-Barrett versus USA Underwriters and John Doe. This lawsuit relates to policy opt-outs and policy rescission based on misrepresentation and how it affects an uninsured/underinsured motorist claim. The facts of this matter are that plaintiff's husband applied for an auto policy with defendant USA Underwriters for a policy period of November 2022 through November 2023. Plaintiff's husband chose to explicitly opt out of PIP medical benefits on the policy application. Furthermore, in the application, plaintiff's husband represented that in the past 3 years, neither he nor any of his rated household members had their driver's licenses suspended or revoked. USAU later learned that both plaintiff's and her husband's driver's licenses were suspended within 3 years before the application date. Plaintiff was later involved in a hit-and-run accident, and a claim for both PIP and UM/UIM benefits was made under her husband's policy. USAU rescinded the policy on the ground that during its investigation, it was discovered that the policy application contained material misrepresentations. Plaintiff then filed this action seeking payment of benefits. As to the claim for PIP benefits, under MCL 500.3107D subsection 1, drivers may opt out of PIP medical coverage if they have qualified health coverage. Accordingly, there was no PIP medical coverage under the policy, and the Court of Appeals found that the trial court did not err by determining that USAU was not responsible for paying these benefits. As to the claim for UM/UIM benefits, such benefits are purely contractual and not by statute like with PIP. Plaintiff's argument was that her husband did not knowingly or intentionally make a misrepresentation with respect to the policy application. The court noted the plain terms of the application, quote, do not state that the misrepresentation must be intentional in order for the policy to be voided. It merely states that any material misrepresentation will void coverage, and no coverage is provided, and the policy shall be null and void from inception if any information in this application is false or misleading, unquote. Furthermore, an affidavit from USAU's underwriting representative stated that had plaintiff's husband answered the question in the affirmative, the policy would not have been issued. Because USAU relied on the misrepresentation when determining eligibility for coverage, the misrepresentation was material. Ultimately, the Court of Appeals found that the trial court did not err in granting summary disposition for USAU because it was not responsible for paying either PIP or UM/UIM benefits. Finally, I wanted to discuss the trending topic in PIP litigation of the parked vehicle exception under MCL 500.3105 subsection 1 and discuss a recent to be published decision from the Court of Appeals on this topic relating to property protection insurance benefits or PPI benefits. First of all, the statute pertaining to the parked vehicle exception, MCL 500.3105 subsection 1, states that accidental bodily injury does not arise out of the ownership, operation, maintenance, or use of a parked vehicle as a motor vehicle unless any of the following occur. A, the vehicle was parked in such a way as to cause unreasonable risk of the bodily injury which occurred. B, except as provided in subsection 2, the injury was a direct result of physical contact with equipment permanently mounted on the vehicle while the equipment was being operated or used, or property being lifted onto or lowered from the vehicle in the loading or unloading process. C, except as provided in subsection 2, the injury was sustained by a person while occupying, entering into, or alighting from the vehicle. In the recent to-be-published decision of the Court of Appeals of Fremont Insurance Company and Frankenmuth Insurance Company versus State Farm Mutual Auto Insurance Company and Jeffrey Lynn Gibbs, issued on November 6, 2025, this exception was the main point of discussion and also discusses PPI versus PIP benefits and how they can collide. The interesting facts of this case were on November 25th, 2022, driver defendant Jeffrey Gibbs fell asleep and crashed his Ford Transit into a parked Ford Escape insured by State Farm. The impact pushed the Escape into a Hungry Howie's pizzeria, damaging the building. The plaintiff's insurers of Fremont and Frankenmuth insured the building owner/involved pizzeria and paid about $64,000 in property damage and sought reimbursement or PPI benefits from State Farm. The parked Escape's driver, named Kaylee Gibson, confirmed that her vehicle was properly parked, unoccupied, and not being used when it was hit. The question was whether this parked vehicle was involved in the accident for purposes of assigning responsibility for property protection insurance benefits under MCL 500.3125. Specifically, the question was whether a properly parked vehicle struck by another moving vehicle and pushed into a building is involved in the accident under MCL 500.3125. The trial court granted summary disposition to State Farm, finding that the Escape was not involved in the accident under Michigan law, relying on the case of Turner v. Auto Club Insurance Association. The Court of Appeals concluded that a line of Michigan Supreme Court cases, namely the cases of Miller, Hurd, and Turner, determined the outcome of this case. In Miller v. Auto Owners, parked vehicles are treated like stationary objects unless being maintained. Hurd versus State Farm ruled a parked vehicle not in use as a motor vehicle is not involved. And in Turner v. Auto Club, they ruled that a vehicle is involved only if it is being used as a motor vehicle and actively contributes to the accident. Under those decisions, a parked vehicle is generally treated as a stationary object, akin to a tree, signpost, or building, when determining whether it was involved in an accident under Michigan's no-fault statute. While these cases also suggest that a parked vehicle may be considered involved if one of the parked vehicle exceptions in MCL 500.3106 subsection 1 applies, that provision is specific to PIP claims and does not expressly extend to PPI benefits. The court added that none of the parked vehicle exceptions applied here in any event. The court was unpersuaded by Fremont and Frankenmuth's arguments based on groups of cases that it referred to as the, quote, spontaneous combustion quote, spontaneous combustion cases, unquote, and the, quote, traffic cases, unquote, finding them distinguishable. Rather, the court concluded that because the Escape was properly parked, unoccupied, not in use as a motor vehicle, and played no active role in the accident, it was not involved in a motor vehicle accident within the meaning of MCL 500.3125. Thus, the trial court found that State Farm was therefore not liable for PPI benefits and affirmed the trial court's decision. That concludes the November 2025 edition of My PIP Monthly. If you have any questions, comments, and/or concerns, please feel free to reach out to myself, Caitlin Milroy, or Mark Masters directly through the contact info in the corresponding slide. Thank you all for tuning in. Be sure to tune in next month for the latest case law update and trending topic in the PIP world. Take care, everyone.